in that case is Yee versus Riccardi, if I'm saying that right. Each party will have 15 minutes to argue. The appellant may reserve up to 5 minutes for about how long would you like to reserve?
3 minutes.
3?
Yes, Your Honor.
Got it, thank you. I'll be keeping time up here, you can't see the clock, so when you get like a minute left of your time, each of you all let me know there's about a minute. Just so you have some idea that you're coming to it. Arguments are being recorded, so when you come to the podium, please introduce yourself. Stay behind the podium, because we're video recording you, will lose you if you start wandering about, and also we may lose you, your audio recording if you go too far too, so please speak in loud voice so we can hear you. If in this case you feel the need to refer to one of the children or anyone, please do use initials rather than the full name of the child, if you would do that for the record, please. We read your brief and are ready to proceed whenever you.
Thank you, Your Honor. Ready. Good morning, Your Honors. And may it please the Court, I'm Anthony Pecora. I'm representing the appellant Valerie Riccardi. Your Honors, first, I think that the Court should be aware of who we're talking about in this case, and we're talking about a minor child, DR, and who will be 6 years old this coming September. We're talking about Valerie Riccardi, who is a single mom, never married to this child's father. There's never been a divorce, there's never been a legal separation, a dissolution of marriage, or even a child support proceeding prior to any action filed by Ms. Yee. That is important, we believe. We also would say, Your Honors, to the Court that Martin Nieves, who is the putative father, or at least at the time of the hearings in question, had not established paternity, had not provided or asserted any rights administratively through the child support enforcement agencies, had not filed any registration of birth, of acknowledgement of paternity, had not finalized any acknowledgement of paternity through any court system or an administrative system as required by statute.
Was there some proceeding in CSA regarding paternity before the act was filed in the Domestic Relations Court?
Correct, Your Honor. So,
number one, is that part of the record before us? I understand it mentioned in the brief that that get filed, so I'll make sure we're talking record evidence. That's somewhere in the record.
it's mentioned in the motion to vacate.
Okay.
That indeed Mr. Nieves had filed an action to establish parental rights responsibilities, that there had been indeed orders for the parties to attend, I think, the CSCA for genetic testing. However, prior to any finalization and test results, Mr. Nieves was convicted of domestic violence, and my client had obtained a 5-year protection order against Mr. Nieves, protecting herself as well as the minor child. The case was then dismissed.
Did CSCA make at any point under a record a determination of paternity in this matter before the domestic case was filed?
No, Your Honor. In fact, the appellees even admit that and state that in their briefs, that it wasn't until recently that had been finalized. There had not been any determination of paternity finalized through the agencies at all. In fact, again, their brief, I believe, page 7, lines 6 through 9, makes that statement that they acknowledge that. So nothing had been officially established. I think at the dismissal of the case, everything kind of went away until Ms. Yee had filed the matter in the juvenile court, utilizing Ohio Revised Code 3109051, which Magistrate Butler indicated in his dismissal of that action. Wrong court. You're trying to seek this grandparent visitation under 3109051, or in the juvenile court, you can't assert that there's a divorce, dissolution, legal separation, or child court proceeding. He dismisses that action, and then the matter is refiled under the same statute, despite there not being a divorce, legal separation, dissolution, or child support.
And I've not had a chance to see the complaint yet in the record.
Sure.
So when you say it was under 3109051, it specifically indicated the body of the brief were filing under that statute, or was it more just, I took it from at least one of the briefs that it was kind of a generic statement of, here come grandparents, wish to have grandparent visitation, didn't cite a specific statute.
Your Honor. So the domestic relations court's decision for Magistrate Butler does not specify that he's making a ruling pursuant to any particular statute. It's void of any statutory schematics. But it's our position that in the domestic relations court, as he stated in the juvenile court, Rom court, you're using the domestic relations court statute, which would be 3109051, as the basis of her request for companionship in the domestic relations court. He doesn't reference 310912, which would pertain to an unwife mother, which would also then require all the other accoutrements to grandparent visitation in the juvenile court. The establishments of paternity, the findings or an action under 3111, an action where he's finding an acknowledgement of paternity with the birth registry. None of that happened. Again, they agree with that. They stated in the briefs. None of that happened until recently. So the cart was before the horse, before the court, in the sense that none of the conditions precedent for Ms. Yee to come to court and seek this grandparent visitation occurred. None of it. None of it. We have an empty seat. Our client is alleging in a sworn affidavit, never received notice, never received service of this complaint. She had previously been heavily involved with litigation in the juvenile court, had the counsel vigorously defended her position that grandparent visitation should not occur or should be significantly limited. She had an attorney. We have a statement, an unsworn statement by the appellee and her trial counsel at the time of the motion to vacate. Well, we served her personally. Well, that's not sufficient. We have a sworn affidavit from Mr. Riccardi saying never received any service of this complaint. Had I done so, I would have been there like I was then and like I am now. This is important to me. This is a child who until the hearing had not really known Ms. Yee. This is where this is kind of an egregious, in my opinion, finding an order by the trial court. A full weekend every month for a 4-year-old at the time, who had not really met Ms. Yee to that point, maybe when he was 1.5 years old, 2 years old, but a 4-year-old who's never spent a night away from his mother.
Counsel, didn't the magistrate say that there was actually visitation prior to 2020? The actual decision talks about that occurring before 2020 when the child was 1.5 years or 2, before the domestic violence, before the parties separated their lives. So there was familiarity to some degree, it just hadn't been in recent years.
And for a 2-year-old, I suppose so. I mean, I'm father of 6, and I know there's my 2-year-old at the time would look at me, maybe I'm dad, maybe I'm not. My 4-year-old definitely knows I'm dad. I guess there's a degree of familiarity that's quite different for a child who is maybe not verbal to a child who's not 4, ready to go to preschool. He knows who grandma is. So at that point, at the time of the hearing, no idea, really. We have a person coming to his door with the police to start the first visitation. Well, that should shock the conscience of anybody, I would suppose. Particularly a 4-year-old who's spent every night with his mother, never has been even at maternal grandparents' home, let alone a person who is now trying to reintroduce themselves into this child's life. So, again, we have a situation where there is a lack of service, at least from our perspective. Our client has never received a service by a process server where she's receiving service of the actual complaint itself, the petition itself.
Did the trial court make any finding regarding whether there was service in its orders?
No, it's looking at the court's decision. Unfortunately, it's about 6 pages, 6 lines long. And there's really not much discussion other than the court attempted to try to resolve the case in her motion to vacate hearing. Didn't necessarily want to hear any additional testimony or statements
muted my client when my client was trying to make the statements that she felt was important. This is a Zoom hearing, it wasn't in person, unfortunately. And, you know, there's basically, the court finds her arguments to be, my client's arguments to be disingenuous without explaining why.
Was it an evidentiary hearing at that point in time, or just decided on briefs of your? I mean, were people sworn in with testimony taken in that regard?
No, Your Honor, it was just simply a Zoom hearing where Judge Swensky asked us to tell us why the matter should be vacated, and she went into why, you know, why I'm trying to resolve the case, and she acknowledges, though, we cited in our brief, that there's probably an issue under the Court of Appeals in the sense that Magistrate Butler utilized 3109.051, and that, hey, let the Court of Appeals handle it if you guys can't resolve it. I think she might have been frustrated. There was attempts to try to resolve. I believe she may have been frustrated with the lack of progress within that 15-minute, 20-minute Zoom conference, and basically said, if you can't do it, take it to the Court of Appeals. And we are here.
I take it your view is that the only potential remedy for grandparent visitation in this case is 3109 as their unmarried parents.
Correct.
In this particular case.
Correct, and that would be, of course, after all the other conditions have been met. So father, before grandma even gets to that point, father needs to step up to the plate. I think, and I'm not a legislator and I'm not a judge, but I imagine the state of Ohio wants fathers to do what any.
And I appreciate your view of that, and that father has to establish paternity before that can happen. But aside for forgetting that for the moment.
Sure.
Under, I think, 230103, different counties and different juvenile and domestic relations courts have the 3109-12 actions go to different courts, sometimes juvenile, sometimes domestic. Do you know in Lorain County are those 3109-12 actions only filed in juvenile, so that your argument is that domestic could have jurisdiction?
It's my understanding that that is the case, that's why Magistrate Butler, instead of simply saying, well, how can you use 3109-12, he said, you're using 3109-051, you need to go to the domestic relations court. And then it's before him, same magistrate, it's different.
That's what was somewhat confusing to me too,
Yeah.
the same entry in both places. So.
Right, it's like Greeks and Italians, same corporation, different divisions. It's just, you know, it's the same thing. You know, Terry Butler, same magistrates, is utilizing different procedures and different statutes. So our position was, okay, if it is 3109-12, it needs to go back to the juvenile court, and then.
And you're talking about a minute in your time, counsel, just so you know.
Thank you, Your Honor. So, Your Honor, we do believe that there certainly is plain error here. We believe that this is strikingly so, in the sense that none of the conditions precedents, either under 3109-051 or 3109-12, have been met for grandma to even approach the court for this visitation. We believe that because of that, the court should have certainly vacated the order, sent everyone back to the trial magistrate and go through those processes, or at least say the processes need to happen before grandma comes back in. So that, Your Honor, I will yield for the rest of my time. So.
May I begin?
Yes.
Good morning. My name is Attorney Jessica Camargo. I'm here on behalf of the appellee, paternal grandmother. I did not represent her in the lower court. I am only representing her in appeal. So I'd like to first say good morning to Judge Carr, Judge Stevens, and Judge, is it Sutter?
Sutton.
Sutton. I apologize.
Okay.
So before we start today, I would kind of like to give a little bit of an outline of what I'm going to talk about today. I think that there are essentially 3 issues kind of for the court to review. The first is going to be the trial court properly awarded non-parent visitation under 3109.12 because it properly considered the factors both under ORC 3109.051 as it pertains to the best interest of the minor child. So, and I'll just start with that first argument. So, first of all, the juvenile court case is not before us. What's before us is the case in the domestic relations court. My client, Ms. Yee, in her filing, did not specify which statute she was coming from. She basically, essentially, generically asked for grandparents' visitation rights. In the magistrate's decision, although he did cite 3109.51 and no other statute, I don't necessarily believe, from my reading of it, that he was saying she's getting grandparents' rights under this statute. What happens is no matter which statute you're bringing under, you still have to go to 3109.051 to apply the best interest factors no matter what. So we believe that what happened is she was really granted, although not necessarily specified, is that she was granted it under 3109.12, and then he cited 3109.51 to apply the best interest factors as
Has there been a
required.
paternity finding by the agency or somewhere before this act was filed?
So that's convoluted, and let me provide the information. As to paternity, I believe it was brought to the court's attention that there was a finding of paternity as DNA testing had been established. However, what I think Mr. Pecora is trying to say is even though CISA had done the paternity testing and the paternity test results were provided, I believe, that the court had not, that CISA had not filed it with the court yet to establish a court.
So, was this test because of a court case or an administrative action?
It was because of an administrative action.
So in that administrative action, had they entered any kind of order of paternity? And if so, is that in the record? Not in the record, but do we know if that was at any time done and submitted to the court, or was just the test submitted to the court and not a finding?
So I believe that the test and maybe the findings were presented to the court, but at that time, it was not, I guess you could say, certified by the court. It was still going on and we were waiting. And they ended up, after this case, finding summary judgment in another action for child support and paternity where mother did not dispute. And in fact, in any of her briefs, she does not dispute paternity, which I find interesting. So we were kind of like in the midst of the process.
I need to say this, but I'm very confused. So what was actually presented as evidence to the court that your client's son was legally responsible for this child?
It was the finding by CISA of the paternity results.
Okay, and how was that introduced?
I'm not entirely sure. I believe it was believe it was a certified paternity.
Because there really wasn't anything done here, was there? Because the mom did not appear.
Well, I'd like to get to that because a little bit about the service issue. If you look at the docket on January 9th of, I think it's 2023 here, what we have is a process server who files that he has personally served mother with it. Now, and there's a difference between service and actual notice, and if you look into my brief, I kind of go into that and how mothers, 2 months waiting, there's a few issues with that. First of all, her affidavit is very self-serving, and I don't believe the court should consider that because she was actually served by a process server, and it's noted on the docket. Second, what she did with her motion to vacate, essentially, was she tried to substitute that motion to vacate for an appeal or an objection, and the time had run out. In addition, as to all of the other hearings, they had been sent out, according to the docket, to mother, and there was never any notice that she didn't receive it. She didn't claim that her address was different. She didn't change her address. And so, from our perspective, the service was good.
Did the court make specific findings about service being good in its order on the motion to vacate?
I would have to look, I don't recall. I think they found that mother was disingenuous. That was the finding. They did not find her credible.
How do you make that finding in an affidavit? There was no hearing, right?
My understanding is maybe there was a Zoom, but there wasn't any full hearing on it.
So the only thing in front of the court was an affidavit from from Mom that said, I never received anything, nobody handed me anything, nobody served me with anything, I've never received it, and that's why I wasn't there.
And then there was, then there was, I believe, the notice, or the Zoom hearing of whatever.
Right, but your client never responded with a competing affidavit, or there was no testimony, nothing under oath that was presented to the court. That I understand that the docket did reflect service, but other than that, once the affidavit was put into play, there was no response.
Other than in that Zoom hearing, or,
Right. Okay.
I would say, Your Honor, that, I'd like to just touch a couple bases on a few points. It is, so first of all, insofar as this motion may be construed seeking relief under, Civil Rule 60B, it is well established that the motion cannot be substituted for an appeal, which is exactly what was done here, and that the party must timely object to preserve error up for appeal. Ordinarily, errors which arise during the course of the trial, which are not brought to the attention of the court by objection or otherwise, are waived and may not be raised upon appeal. And I'd like to touch a little bit more based on, there's case law in my brief that the court will not reverse the judgment of a trial court where it reaches the correct result for the wrong reason. So even if the court were to have thought, 3109.51, he could have established it under, 3109.12, whether it be the wrong reason, the court still, it shouldn't be reversed. But again, our argument is that it was 3109.12, and then we went to the 3109.5 is only for the purposes in grandparents' visitation to establish the best interest factors.
As far as the jurisdictional question, if this was an action under 3109.12, can it be filed in the domestic relations court in Lorain County?
I've seen it both ways. I think they tend to, if it's 3109.12, that's a good question because I've seen it both. So, and I don't think that it's necessarily wrong for that to be heard under either or. The Ohio Supreme Court in Martin held that even if a punitive father was the father of a child in question, the alleged paternal grandparents were not entitled to court order visitation. Their argument there is misplaced because that was post-adoption case. So I just like the court to know in reading that would not be something that even applies here. Appellant offered no evidence or argument to refute that the defendant's paternity of the minor child is in question. Rather, she simply took place with the fact that paternity action itself didn't reach the final determination, and courts have ruled on that. They have said that, as such, the trial court did not err in addressing appellant's objections to the paternity action as a precursor to a hearing on grandparents' visitation actions. But in any event, it did not prejudice the parties in doing so, and it goes on, I believe it is in either Oliver v. Fendler, to indicate that essentially the court can look at those certified paternity records and it could be sufficient enough, and that's also in MHVBK, and where they said that based on the evidence, paternity had been established and that it was good enough.
Did the magistrate in this case, when he or she issued the visitation order, did they make a finding of paternity at that point in time? If you know, we could check, if you know.
I
don't recall seeing
I
one,
know that it was brought, probably, I believe that it was brought to the court's attention because they accepted it as a visit, so it would have been probably in the transcript. As to the order not having it before me, I don't know, but I would certainly hope so. Essentially, wrapping up, I think that the brief speaks for itself. I would touch on the fact that my client, that even though it's not before the court, that as if we were to go back, that the paternity issue, I think, is really, I think I raised maybe, plain error in some ways. I have to raise it. I think it would be wrong if I didn't raise plain error. But if the court finds that for some reason it wasn't sufficient, because even if we go down, now we do have it through the court has accepted the fact that paternity has been established in the JG case. So even if we go back down, and that is if the court finds it's a deficiency, it will certainly have been cured if the court brings it down, but we believe that, again, it's sufficient. I want to touch briefly on the relationship between my client, although that technically wasn't really in the briefs, but it was mentioned by Attorney Pecora. My client had visitation, well, not court ordered, but was visiting with the minor child. It wasn't until the domestic dispute happened between father and mother that she decided that she was no longer going to allow grandmother to essentially see the minor child. Grandmother was not an advocate for what her son had done or didn't do. Obviously, that's between him and the mother, and arguments that should be raised whether he should have visitation or not. But grandmother was simply there to see her grandchild, and to her it wasn't about her son or the mother, it was about maintaining that relationship, that is so important to the child. And so although there was some time in between due to no fault of my client or mother's, or the child, there was an established relationship. And to say that there was not much of one is somewhat disingenuous. Any halting was due to the fact that I believe mother simply felt, perhaps it's from what I'm gathering, that because it was mother's father, or that it was father's mother, that somehow she may have some allegiance to father, and that kind of broke things down. So, any other questions?
No, thank you.
Thank you.
Just if I may clean up some of the issues, the questions pertaining to the court's findings denying the motion to vacate. The judge indicated that my client's arguments were slightly disingenuous. So I don't know what that means. I mean, I know what it means, but I don't know what it means. I don't know what part of her arguments she was referring to. She doesn't really say. And then she just goes on to say that there's insufficient grounds to vacate the order. We obviously disagree. As it pertains to Magistrate Butler's decision itself, Magistrate Butler's decision indicates that he's making a decision under 3109.051. We all know that includes D, which would be the best interest factors, but then there's B, as in boy, B, which talks about you can use this section if there's a divorce, legal separation, annulment, and child support proceeding. That is the portion that's missing in his decision. There's no finding because he can't find it because there was none. He doesn't say I'm making the findings under 3109.12, which would be unmarried mother, juvenile court. So wrong court, right statute, wrong facts, they don't apply to this case, and that decision should never have been made. Pertaining to the my client's position on her service, this court has ruled that a defendant can rebut the presumption of proper service by presenting sufficient evidence such as an affidavit, which she did present in her motion to vacate. Ms. Yee's trial counsel presented nothing other than she believes there was service or something's on the docket about service. No sworn statement from her processor that on this day I actually went to, I saw this person, identified myself, I knew this was her, and I served her. He didn't. Nothing was presented to the court at all that's sworn, which would rebut my client's position. This court has previously held that the defendant's uncontradicted
affidavit that the defendant did not receive service of a complaint is sufficient to rebut the presumption of proper service. It goes, the court has also ruled that where a party seeking a motion to vacate makes an uncontradicted sworn statement that she never received service of the complaint, she is entitled to have the judgment against her vacated, even if opponent complied with Civil Rule 4.6.
Yeah, about 30 seconds left here, about counting, like this up.
Thank you. With that, Your Honor, I think I will rest. We'll indicate that we believe that there was sufficient evidence for this court to vacate. When it pertains to personal jurisdiction, this is a de novo review by this court as to whether it was actually met. So we would believe that this court should affirm our appeal. Thank you.
Thank you. And let me ask a question to either counsel at this point. You do know we have a mediation department at the court. Have you had any opportunity to attempt to mediate through the court? Not knowing results, but just have you had an attempt?
We did.
Okay.
We did. And actually, the parties are actually on their own doing whatever, good things on their own, but we did attempt mediation.
Yeah,
So,
I agree that there was some mediation attempted, and there were some good results from that, and
they seem to be doing that on their own.
They're visiting, just not necessarily according to the orders,
Then let me take a moment, without again getting the results, and I didn't intend to do that, but certainly on behalf of the court, then giving out appreciation to your clients for working through these family issues together as best they can through mediation, and otherwise, and while this matter is pending, if there's further need for mediation, that would be available through our court, certainly so.
Correct. Thank you, Ron.
Having said that, the court will take the matter and advise at this point in time. When we reach a decision, that decision will be mailed to you by the clerk of courts and also be available on the Ohio Supreme Court website. And I thank both of you for your presentation.
Thank you.
thank you very much.